we're glad to be here for you. And I got nowhere else to go anyway, so I might as well be working. And all I can say is thank God it's Friday. Not that I won't be working the next 2 days, but at least I won't be doing any Zoom meetings the next 2 days. I'll be trying to catch up on everything else. Anyway, so good to see you guys, figuratively. Wish I was there in person. I can't wait till I can start doing that again. But I just want to give you sort of a legal update, what's going on out there. And I realize I'm talking to people in Orange County, which is good news. Good news for you guys, because Orange County, unlike some places like LA County, LA City, many counties in Northern California, Orange County hasn't restricted realtors any more than the state has restricted you. So that's good. What happened was, as you know, about a month ago, the governor said, yes, real estate is essential. What realtors do is essential services, but it's not business as usual. In other words, if you want to be in compliance with state law, and you all need to be in compliance, you have to follow certain best practices. In other words, and we've put those best practices onto a document that's available to you, but to really make it easy for you, we've incorporated the best practices into a couple of CAR forms. The idea is this: if you use these forms and have everybody sign them, you know you're complying with the law, with the rules, and your clients are complying as well, which means you can't get sued. Or if you get sued, your clients have to indemnify you and your E&O will cover you. If you do not follow these rules, these protocols, the best practices, your clients are not indemnifying you, you could get sued, and you won't have E&O, which is why it's very much in your interest to comply with these rules. And the rules are embodied on these forms. The forms, real quickly, the first form that's real important to know is the Coronavirus Listing Addendum, RLA-CAA. So what you want to do is, when you take a listing, or you're already in a listing, please have your sellers sign this form. When the seller signs this form as an addendum to your listing, they are promising that they're going to follow the safe practices. And they're not going to violate any rules. And anyone who comes onto the property, they're going to make them sign this other form I'm about to tell you about. And they understand that the broker's doing the best efforts, but you, the broker, are not in a position to verify the information that other people put on these forms, et cetera, et cetera. Good indemnification language, good protection language, and it reminds everybody to follow the best practices, including you're only going to show the property to one agent and two buyers at a time, and everyone's going to follow social distancing, everyone's going to wear gloves, everyone's going to wear a mask, people aren't going to touch stuff, and every time after each showing, the seller's going to disinfect the house. What does that mean? Well, if nobody's touched anything, that might be pretty limited wipe down, but the point is the seller is promising to do that. And you're promising, both the broker and the seller are promising to follow the rules and don't let, to the best of your ability, don't let other people. But like I said, though, you're not the police. As a broker, you can't, if a buyer shows up and doesn't want to wear gloves, they're not supposed to come in, but you don't have to like physically throw your body in front of them to make them stop. Hopefully they'll be persuaded not to go in, et cetera, et cetera. Just like you don't have to verify the information. Now, the second form, the even more important form, is the PEAD, the Property Entry Advisory and Declaration. The best practices and the listing addendum I just mentioned basically says you're going to insist that any buyer or buyer's agent or inspector or appraiser or anybody who enters the property is going to follow safe practices. And also, by signing this form, they're basically saying to you, saying to the seller and listing agent, I'm not sick. As far as I know, I haven't been in contact with someone who's sick. As far as I know, I have no symptoms, etc. But there's disclaimers there saying that, of course, nobody can verify that. You don't know if someone's telling the truth. Some people are sick and don't have symptoms. The point is, everyone's sort of, by signing this form, they're assuming the risk. There's no such thing as no risk at all when you're out and about in this situation, but they're indemnifying you and assuming that risk, which is very important legally, of course, from my perspective, but it's just very important in general that you comply with this. Are the forms mandatory by law? No, but what's in the forms is mandatory by law in LA, in California, and in Orange County. So by you signing these forms, you're demonstrating you're in compliance with the law, and you are in compliance with the law. You're declaring, health situations and things like that. Good forms, important forms. Two more forms I want to mention. There's a good form called the CVA, the Coronavirus Addendum. This is the form that the buyer and seller might sign as part of their contract once they get into the contract, where both of them are agreeing, hey, we're in this situation now. Sometimes things happen in escrow that makes the escrow longer than normal. Maybe having problem getting a review appraisal, the lender's behind, the inspector's behind, it's having trouble getting a notary out, buyer lost income, there's a new stricter order just got imposed by this particular city I'm in, or I got sick, I have to take care of a sick relative, whatever. Things can happen that means you can't perform on time. Maybe you can't remove your contingency on time, you can't close on time. By agreeing to this form, the buyer and seller are agreeing that if something like this happens, if it happens to you, you're going to notify the other party that it happened, and then you can agree right on this form. Everybody agrees if something like this happens, there's an automatic extension of 30 days, 20 days, whatever you want, of the buyer's obligation to remove a particular contingency, or the seller's the obligation to close on either side. And then if something does happen to you, then there's the fourth form, the NUCC, the Notice of Unforeseen Coronavirus Circumstance, which is you're going to give to the other side and says, remember we anticipated something might happen that might delay performance? Well, guess what? It actually happened. So now this kicks in the whole extension that we agreed to on the other form. Are these forms mandatory? No. But it's a good idea, because when these things happen, wouldn't it be nice if you've already anticipated it and the parties have agreed what happens? People ask me, what if we don't sign this form? The buyer's in the middle of escrow, but they lost their job, but they've already removed their contingencies. But there's no form like this. So what does that mean? By the way, this form, you can also put on this form, the buyer and seller agree if something like this happens, both sides agree to a mutual cancellation, including canceling the escrow as well. So the question, of course, is what if I'm in escrow, buyers remove their contingencies, and then something happened causing them to be unable to close on time or unable to close at all, but they've removed their contingency. Do they lose their deposit or not? Well, if you use the form, you can put right on the form whether they lose their deposit or don't lose their deposit. Of course, some buyers are going to say, I'm not signing that form unless I get my deposit back. Some sellers are going to say, I'm not signing it unless I get the deposit. So maybe they won't sign it, which goes back to my question. If they don't sign that form and something goes south in escrow, does the buyer get their money back or not? Well, there's something in California called the Act of God law, which basically says if you're in a situation, if you're in a contract and something happens, the language is if something your performance is prevented by some irresistible superhuman cause, then you don't have to perform. In other words, like there's a war, there's an earthquake. Well, the question is this pandemic going to be considered a superhuman cause, supernatural cause that's going to permit people to get out of their contract obligation, not their rental obligation, but their purchase obligations? And we don't really know. I suspect yes, but rather than wait for the judge to decide, it's nice to have a form. You know what else? What if the buyer says, well, I lost my job because of COVID-19. I can't perform. Courts might say, okay, yeah, you get your money back. What if the buyer says, well, I haven't lost my job, but I'm worried that I'm going to lose my job, therefore I don't want to buy this house? Is that going to be considered ground justification to cancel and get your money back? We don't know. We don't know where the line is. It's nice to have a form, okay? So that's what I want to tell you about these forms. By the way, if you've been using these forms for the last couple of weeks, they all just got updated today in a good way. We took people's comments and we improved them. Nothing is significantly changed. There's just more good disclaimer language in there, more good warning language. I think if you've used them before, you look at them now, you'll say, yeah, that's a little better. It flows a little better. I mean, when we first came out with these forms, we did them in like 24 hours. Usually forms take about 6 months to come out. But anyway, so those are the 4 forms I mentioned. And guess what? On Monday, 3 days from now, we're going to have brand new forms that are just like these forms, except they're specifically designed for lease rental situations. So we're going to have a lease rental coronavirus addendum, a lease rental property entry advisory and declaration. I mean, up until now, you could have used these forms for rental situations, but we didn't have a, now we're going to have forms specifically for the situation of it's a lease property rather than a property for sale. So that's good. Okay, what else do you need to know out there? Speaking of rentals, it's very complicated. Some cities, I forget if any Orange County cities have put in these eviction moratorium. You can't evict for someone. Some cities say you can't raise the rent right now, whether you're under rent control or not. Some cities say tenants, you can't evict them for not paying rent if the non-payment is because of the coronavirus, and then they don't have to pay you back for 6 months after that. The state simply says no evictions until May 31st, if the reason for not paying the rent is related to coronavirus, but the tenant has to tell the landlord in writing why they didn't pay the rent and prove that it was related to coronavirus. So we got a couple forms for that, which are the last 2 forms I'm going to mention. One's called the NTAP, the Notice to Tenant about Ability to Pay Rent. This is the form the landlord sends to the tenant and says, well, I know she didn't pay your rent. You know, there's an eviction moratorium, but you still got to tell me why you didn't pay the rent, and you owe the money back when this eviction moratorium is over. Like I said, some cities, though, have slightly different rules. How do I know if my city has a unique special rule on evictions and rent freeze? Call the CAR legal hotline, my hotline, 213-739-8282, or we have a nice spreadsheet on the new CAR microsite on coronavirus, car.org/coronavirus. And there's a spreadsheet showing you, actually, I don't know, it may not be up on the spread till later on, but it's on the legal website right now. It's just search eviction moratorium, and it'll tell you if there's any special rules for your city, okay? But then to complicate everything I just said, guess what? The court system in California basically shut down. Not completely shut down, but shut down slightly, in the sense that there's certain types of lawsuits cannot proceed right now, including unlawful detainers, which means, in addition to everything I just said, even if the tenant has no hardship at all, so you have the right to evict them, the courts won't process the unlawful detainer right now until August 1st. Maybe that'll open up sooner, we don't know, but right now it's August 1st. But that means come August 1st, unless the tenant fits into this category, I mean, they got to pay all the rent that they owe on August 1st, unless you're in a city that has a more specific rule that gave them a longer extension, if you're following that. What if I'm selling a property and there's a tenant in there? First of all, does the tenant have to allow showings? Yes. They can insist that everybody signs these forms, safe practices, but the tenant can't refuse a showing, all right? Well, what if the tenant says, I don't care what you say, I don't feel safe with people coming in here Nobody can come in. What can you do about that? Well, you can evict the tenant, but you can't evict them till August. So you have a problem, don't you? Well, you do have a problem. The only thing I can say is you can tell the tenant, you know, if you don't allow these showings, you may cost us this sale. If you cost us the sale, that's going to have financial repercussions on a lot of people, have a lot of money, and we're going to hold you personally, legally responsible for all those damages. So not only am I going to evict you when I have the right to, but we're going to sue you for the damages also. Maybe that gives you a little leverage. I don't know. But anyway, that's the latest on rentals. That's the latest on forms. That's the latest on what you can do and what you can't do. Another thing that's going on right now, you might have noticed, is a nationwide foreclosure forbearance. This doesn't apply to all loans, but a lot of conforming loans or FHA or VA loans, basically, you don't have to pay your mortgage payment for 3 months, and they'll tack it on to the end. This is not all loans, but it's a lot of loans. Other loans in California, jumbo loans, direct loans, there's something else going on. There's a foreclosure moratorium. This doesn't mean you don't have to pay it back. I'm sorry, it doesn't mean that you can not pay and tack it on to the end of the mortgage. It just means if you don't pay, then you can get, they can't foreclose on you until June 23rd, I believe it is. But that means on June 23rd, you got to pay all the money. So there's no reason not to make your mortgage payments in that situation. But this is obviously complicating the lending world very much. What else is going on? The DRE just said that if your license is up for renewal in the next 60 days, you can extend it 60 days beyond that. If you're doing a 1031 exchange and you're approaching a deadline to identify the replacement property or close on the replacement property, your deadlines are automatically extended till July 15th. Appraisers have a lot more relaxed standards now. They can do a lot of drive-by appraisers. And if you're doing a refi, most refis, the appraisal doesn't have to be done until 120 days after the close. The insurance commissioner basically said that insurance companies should be issuing rebates, refunds to people on their insurance premiums on certain types of insurance, such as car insurance, because we're not driving, so why should we have to pay all of our car insurance? Is that going to apply to E&O? We don't know yet. I'd say probably not. Let's see, anything else you should really need to know? The last thing you should know about, of course, as a realtor is, and you can find a lot of information on this on the coronavirus, on the car.org/coronavirus microsite, is that there are government programs out there that will provide relief and put money in your pockets. And I have good news and bad news. There are 3 programs. One is called the PPP Payroll Protection Program. One is called the EIDL, Emergency something disaster relief. I don't even know what it stands for anymore. And the last one is called the PUA. I'll get to all 3. The first one, the SBA, PPP, this applies to companies and applies to independent contractors. Basically, you can apply for, through your lender, a loan, basically to recover lost income, to pay, if you're the business owner, to pay payroll, to pay utilities, to pay mortgage interest, to pay rents. You have to use the money by July 1st, and you basically have to, if you're an independent contractor, you have to prove, you know, the money you made last year compared to the money you made this year. They're complicated things, and I'm not the expert. I'm going to tell you how to get the expert advice. The bad news is this program already ran out of money. The good news is everybody says they're going to probably next week put billions more dollars into the system. If you've already applied, that's fine. If you haven't applied yet, don't even bother until they put more, the new stimulus puts more money into the program, hopefully sooner rather than later. The good thing about this loan, by the way, is it's forgivable, depending on the payroll situation, depending on the situation. There's details on everything, which is why if you have any questions on this, you're going to call the phone number of the COVID relief hotline, 213-351-8450. 213-351-8450, or just go to car.org/coronavirus. And that's both of these the second program, the EIDL, this is if you want to apply for money that you don't have, it's not just that you're going to use it by July 1st, you may have ongoing longer loss of revenue, and you want to get money to pay your bills, your debts, your mortgage and all that stuff. And those are not forgivable loans, 30-year, 3.75% interest, but you might also be eligible probably for a $10,000 grant. So which one of those two programs is better for you? You'll have to figure that out. Call that number I gave you, talk to your accountant, and they both ran out of money for now, but hopefully there'll be more money next week. Then the third program might be the best one of all, depending on your situation if you're a realtor, and that's the PUA, the Pandemic Unemployment Assistance. The bad news is right now you can't even put in an application. The good news is April the 28th, Monday the 28th, or Tuesday, whatever day that is the day when they say, the state says we'll be open for business to process your application. This is federal money, but it's got to be processed through the state. The good news is independent contractors like you are eligible for this. Normally you don't get unemployment insurance, but here you're eligible for the pandemic unemployment assistance. And it should last for 39 weeks, retroactive back to January 27th. The whole qualification, you have to call that number to find out this, but everyone's going to be eligible for this. And pretty much $600 a week at least once it's in place. So you'll figure out which is the best for you among these programs. We have a hotline of people, 12 people at a time waiting to talk to you, and there's not a wait time today as far as I know. So check that out. Don't ask me questions on that stuff, but feel free to ask me questions on anything else. And I think I am now ready to answer any questions anybody has on anything.
Gov,
So,
Gov, the moratorium eviction.
Yes.
There's a question from John that says, do these rules apply to the short-term rentals with an exit date?
Of course, it varies in general. What you mean by short-term rentals, where you are. Generally, it doesn't apply to short-term rentals. I would say overall, the general rule is no, it doesn't apply to, you can still, people in short-term rentals can't just stay there forever, right?
Okay, and then from Dan Hobby, for a listing where the homeowner is not in the area and cannot disinfect the home after a showing, what are the options other than the realtor disinfecting the home after each showing?
Excellent question. So the forms and the best practices and the rules all say it's a seller responsibility. Okay, the seller's in Vegas, the seller's in Texas, so they can't do it. I guess one possibility is you prepare a disclosure that you give to everyone who comes into the property and says, this property hasn't been disinfected. Would that even be sufficient to be in compliance with the law? Maybe buyers assuming that risk. I don't know if I want to take that chance. So I'm thinking what's probably going to happen is the seller's going to say, well, I'm not there. That's why I hired you, realtor. You need to take care of this for me. So I want you to take responsibility after each showing to do whatever disinfecting is required. And then it's going to be up to you. You could say no, which means you either run the risk of it not being done, or you you don't do it at all, and you don't deal with the listing at all, which definitely is not what you want to do. A related question is, what about that means you probably shouldn't have a property on a lockbox where people have unlimited access to the property, because then how are you going to police the best practice? Not that, remember I said you're not the police, but how are you going to make sure people sign that form, the PEAD form? How are you going to take care of the disinfecting if you don't even know? And you can figure out, but you sort of have to set your lockbox so that people can't just walk in without making an appointment. The best practices require an appointment anyway. So I went off on a lot of tangents there, but the bottom line is, the quick answer is, yep, it pretty much falls back on the listing agent.
Okay, Gov, I see a question in our chat. It's from Natalie Alvarez. She says, I'm currently using the CVA with my CR. I'm removing all CR except other and typing in see attached CVA. I attach the CVA with the typing, and full deposit will be returned if the COVID-19 directly affects the buyer and causes a cancellation of escrow. Does that seem like best practice?
Yeah, don't you love all these acronyms we're throwing around here? Yeah, that sounds like that's legitimate. Yeah, I mean, because that's not really a best practice thing. That's just a contractual agreement you made. I mean, you always have to follow the best practices, but I think what you're just talking about is the way you contractually want to handle this situation, and that doesn't really impact best practices. So yeah, that's fine.
Okay.
From Brian, he says, is the seller expected to sign and provide a PEAD form to the prospective buyers and agent before this prospective buyer and agent enter the unit?
Very good question. I forgot to mention this. I made the point that everyone who enters the property should sign the PEAD form, but I forgot to say everyone who's allowing the entrance should also sign it, listing agent and seller, in other words. Now, as a buyer, do you have to give a form to every buyer who comes in, signed by the seller? It doesn't hurt. I don't think it's actually required. I think it goes without saying, though, hopefully it goes without saying that if the seller, remember you sign that form, you declare you've had no contact with a sick person as far as you know. What if the seller knows for a fact that they have been in contact with a sick person? That certainly has to be disclosed to the buyer or anyone else who enters the property. The PEAD form would be a good form to use to do that. To get back to so let's say the seller, yes, it says in that listing addendum, seller will sign that form. So make sure listing agent, the seller signs it. But let's say the seller signs it saying, yeah, I declare I've had not sick, no symptoms, no contact. I agreed that I disinfected the property after each showing. If the buyer wants to see that, fine, give it to him. Why not? But I'm just saying, the buyer trusts you. You don't actually, there's nothing that says you actually have to give it to the buyer or the buyer's agent. Whereas the buyer and the buyer's agent, they actually promise they actually will provide this form to the seller. But the more I think about this, thinking out loud, as a buyer's agent, why not ask the seller to give you one too? So everybody's happy. Everyone's agreeing that everyone's following the rules and nobody's sick as far as they know. So it's a good question. I'll sort of modify my answer and say, yeah, why not? Why not? It's just not specifically required in the form.
Okay, we have a question from Pamela Horton. She wants to know if I have an out-of-area seller and want to have it disinfected. Can you hire a company?
Yeah, you can hire a company. My gut reaction is that seems kind of expensive. But yeah, I mean, if you want, I guess you're not talking about a vacant property. So yeah, an occupied a property that's not vacant, but the seller's gone. You know what I'm saying? If it's just vacant, it would seem to me, if everyone is following the protocols, they're not touching anything. So there's not a whole lot of disinfecting that has to go on other than wiping down the doorknobs, maybe. If it's going to be more cleaning than that, maybe it is worth it to actually hire a company to come out and in which case it wouldn't be the agent. The agent's delegating that responsibility. The seller's delegating that responsibility to a cleaning company. So I think that's okay too. I'm just thinking it might be not necessarily necessary and maybe kind of expensive, but sure, you can do that.
Can I ask a follow-up question to that maybe
Sure.
here? So on that note, this has been going on a month of thinking out loud, just like you were. Has anybody come about an idea of having a company that actually does this, is certified, covers insurance for any liability, to answer Pam's question directly?
I think it'd be a great business opportunity for somebody. I haven't heard about it, but
Nor have I.
yeah, you would think something like that. That's what I was wondering about the cost of that. What would make it worth it? But because I've some agents around the state tell me, they're going to be 20 people coming to the property today. I got to clean it 20 times. And I say, well, you got to do basic disinfecting, whatever that means. So yeah, you have to do it 20 times. So maybe a company that would agree to do that. You never know. But yeah, I haven't heard about it, but I was wondering that myself.
We have a question from Sonia. Sonia, I'm going to unmute you so you can ask.
The company is called Decontaminate.
It's called, what is it?
Decontaminate.
Well, there is a company, Decontaminate. There you go.
And it's from $395.
Thanks for the tip.
Dan Hobby has another question. Is there any requirement in the terms of what has to be disinfected and to what extent?
There really isn't, because the state actually federal guidelines is what the governor's order is based on, and they don't really give any any elaboration on what exactly does that mean. So we're just sort of giving you our best guess. I think it just really means just wipe down surfaces that anyone might have touched. I think it's sort of I think that's a safe recommendation. You never know. I mean, there's so much of this as you are gathering is just not black and white. I mean, we're basing on these guidelines that aren't necessarily specific. Some of these orders, the language can be ambiguous. Some of these issues are like courts are going to have to decide, like I talked about, is a pandemic considered to be an act of God that means you can get out of a contract? I'm guessing yes. Or disclosure issues. Do you have to disclose that the previous occupant of the house had COVID-19 but is now recovered? Is that a material fact that needs to be disclosed to the buyer? Myself and my fellow attorneys generally think the consensus is yes, it is going to be considered a material fact. Of course, we don't know that till a court decides that. So much of this is speculation, but I'm definitely giving you the CAR legal opinion on everything. It's not just my opinion, it's CAR's. And it's usually the consensus of the legal community as a whole. But getting back to your specific question, no specific guidelines on what does it mean to clean and disinfect.
We have a comment from Paul that says, my seller of the property is in a nursing home. She wants the home to be shown, and she has not asked the agent to clean it.
Yeah. Remember, I mean, I think it would be the agent's job to tell the seller, it's required that we clean it after each showing. And then maybe the client will say, well, then can you take care of that? But what if the agent doesn't want to take care of it and the seller says, well, I'm not going to pay a cleaning company? Then you're in the position of having to tell each buyer who comes in it wasn't clean since the last showing. And I'm not even sure if that's okay, even if the buyer waives that. So I think whether the client asks you to do it or not, you should probably do it. It's my gut reaction to that. Says Dana Wall has raised hand. That's what I'm seeing. People are raising hands, I guess.
There's another question here in the chat window from Ginger as well, that if a tenant was given a notice to vacate in January, can they not abide by the notice?
So in other words, legally, no, they can't not abide by it. But if you're telling me they're still in the property today, you're not going to be able to physically remove them until this the courts open back up for unlawful detainers. Once they do, you'd be able to and be entitled to back rent penalties, damages that you can prove were caused by their refusal to move, but you're not going to be able to physically get them out right now.
Dana, did you have a question? Would you like to unmute and ask your question?
It was by mistake, she said.
Okay.
Gov, Devin Lucas has a question for you. Any input or discussions with the constitutional law experts on the validity of these eviction bans? And now rumors of California wanting to mandate reduced rent to all the tenants?
Excellent question. So first of all, there's several things. What about a city that just simply says, landlord, you can't evict for a certain period of time? We're pretty sure that's legal and constitutional. What about a city provision that says, landlord, you can't evict and you got to give them 3 or 4 extra months to pay the back rent? Is that constitutional? Maybe, maybe not. But then some cities are actually saying, or they're talking about saying, well, tenants, you don't even have to pay your rent at all for the next 2 months or 3 months. We think that is unconstitutional, violates the Fifth Amendment. If any city does something like that, CAR will get involved to fight that. But then the last thing you may have heard, there's a proposed bill in the California Legislature Assembly right now that's been proposed that would mandate that courts have the authority to require landlords to actually reduce the rent that their tenants have to pay by 25% in certain circumstances. That, since it's a state law, CAR is already in the process of opposing that. We're part of a coalition. We'll probably have red alerts and things like that. We will fight that one big time. If it's a local one, it's, if it ever gets passed, we could get involved with that. Like I said, the ones where they just forced you to delay they give the tenant 3 or 4 extra months to pay it, that's maybe okay. I don't know if we're going to get involved with that. But if they actually try to say tenant's rent is forgiven or reduced, like this proposed state law, CAR is officially opposed, will definitely get involved legally and financially to fight those. We'll keep you posted. Tell us if any of your cities propose anything like that. We're trying to monitor as best we can.
We have another question in the Q&A field. What would you advise regarding current REO listings with no COVID listing addendum currently in place? I expect the seller will not sign.
As you know, in REOs, they always think they're exempt from everything. But if they're in California, and wherever they are, every state has some version of this. If they're in California, whether they sign that form or not, they're still under the governor's order. The governor's order that has been embodied in the best practices and these forms. So, like I said, the forms aren't mandatory, but if the seller still has to comply with these rules. Now, maybe it's an REO. I don't know what kind of contact you have with the seller anyway. Maybe the burden is going to be now put on the listing agent. But the fact that they won't sign these forms agreeing to comply doesn't mean they don't have to comply. It just means they didn't sign the form. So it's a difficult situation you'd have to deal with, but you want to be protected at yourself as a realtor. So you're going to do whatever you can, make your best efforts to make sure that the best practices are followed. The bad news about that situation is if the REO, the seller, refuses to sign that form, they are refusing to indemnify you if there are any lawsuits arising out of any of these activities. If you as a listing agent are willing to proceed anyway and are going to make your best efforts to comply with these rules, you're still going to be okay, but you don't have the seller indemnification that is helpful from a legal perspective. So it's sort of up to you what you want to do in that situation. Sorry, all this is so depressing, but I can't wait till I can talk about happier things, but this is what we're dealing with, right? It's not going to last forever. That's all we can say.
Gov, I know legislation is different than legal, but do you know what the ramifications of the AB 828 are going to do to us?
See, that's exactly what I was talking about. The AB 828, that is the proposed state law that would, among other things, give courts the power to require landlords to reduce their tenants' rent up to 25%. As I said, we're opposing it. I don't think it would pass. I really don't. Our concern is they may modify it to a place where we still don't like it, but it might be passable, in which case we would still fight it as hard as we could. So I don't know about the ramifications. It would be pretty extreme if something like that. I don't think it would survive in the courts, a constitutional challenge. I really don't. But we would try to fight it, obviously, so it wouldn't get passed in the first place.
Yeah, I would hope so, because it also has that 12-month provision in there.
Yeah.
So we do have another question from Ruma Gulage this time. In the revised RLA CAA,
Yes.
why was the indemnity and hold harmless language removed?
Well, you got to read it carefully. It doesn't use the word indemnity anymore, but it still has the hold harmless language. And that was done for legal reasons, legal research on what legally is going to be enforceable and what isn't. That was very carefully drafted for legal reasons. And we still strongly believe hold harmless is sufficient. The holding harmless part is still sufficient to protect you, to require the seller to basically, like it says, hold you harmless. There's not going to be any, if anything goes wrong, we hope it's going to mean that they have to take all the responsibility. I mean, I think if you do your best that you can, you're not going to get liable anyway, but ideally for you, you don't even want to have to defend the lawsuit or even submit it to E&O. But I think bottom line is you're going to have to, your E&O policy requires you to send it to E&O anyway. So you're going to have to pay your E&O deductible pretty much anyway. The question is, are you going to be able to get your client to pay you back the E&O deductible if this actually goes that far? We hope the language that's still there would accomplish that. But we had to change the way it was drafted before. We didn't, after more research, probably might not be enforceable written that way. Hate to be so legalistic today, but that's the way it is. Kimberly, you're muted.
Well, that's not sufficient, is it? I don't see any other questions in the question and answer box. Are there anybody that want to raise their hand and ask questions? Well, look at that, Gov. It looks like you answered everything necessary. Oh,
amazing.
We have one.
Here we go.
So we have one from Rick Gold. So Rick, if you'd like to unmute yourself, you're ready to go.
Can you hear me?
Yes.
Okay, this was asked by my clients. It's not coming from me. So just want to know if it's legal to actually raise rent during this period.
Yeah, unless you're in a city that has imposed a rent freeze. If you're not in such a city, the state hasn't done anything yet. Let me take that back. If you are a landlord of certain types of property where you have a conforming loan on it, yes, there is a federal USA national temporarily eviction moratorium. And for certain loans that even, not many, I'd have to research it for you, but I think there might be some situations where you can't increase the rent. Like I said, I don't have everything memorized. That's a possibility. That's not a strong possibility. The general answer is no. Unless you're in a city that specifically has a rent freeze like Los Angeles, you can still raise rent subject to the new, as you know, California rent control law, which says certain landlords can only increase their rent 5+ inflation. Some cities, I don't know if there are any cities in Orange County, have their own stricter rent controls. But if you're not under that, and you're not in a very unusual situation with certain loans, the answer is you can still raise the rent right now. You just can't evict. You can raise the rent.
Another question came in from Pamela Horton. Could you list the 4 major COVID-19 forms? I was in the CAR at the beginning. Thanks.
Yeah, the 4 forms are the RLA CAA, the Coronavirus Listing Addendum, the PEAD, the Property Entry Advisory and Disclosure, the CVA, the Coronavirus Addendum, and the NUCC, the Notice of Unforeseen, NUCC, yeah, Notice of Unforeseen Coronavirus Circumstance. And remember, as on Monday, 3 of those forms, the PEAD, the CVA, and the NUCC, are going to have a lease rental version. So there's going to be the PEAD LR, the CVA LR, the NUCC LR. But as far as the first form I mentioned, the RLA CAA, there is not going to be a separate lease listing addendum. So if you have a lease listing, use that same coronavirus listing addendum, the RLA CAA. But for the other 3 forms, there's going to be on zip form on Monday, and I think it might even be on the website over this weekend, there's going to be a lease rental version, very similar, but a slightly different version for that.
So it says if a tenant is late to pay rent due to COVID-related circumstances, is there anything that states the landlord cannot charge a late fee?
Very good question. Yes, you can't charge a late fee. In other words, not only can you not evict them, you can't charge a late fee. But you could take the money out of their security deposit. But then you can't evict them for not replenishing the security deposit until May 31st. But then, of course, until August 1st, even if you have the legal right to evict, as a practical matter, right now, you're not going to be able to evict. But you can charge them late fees after May 31st. And if they're not paying and they don't have a COVID-19 reason, you can charge them late fees right away. This stuff is very complicated.
Okay, somebody has a question. If you take money out of the security deposit, is that considered charging or collecting rent?
I'm not even sure how to answer that. I mean, the point is, okay, I can't evict them, but I can still take the money out of security deposit. If that helps, you know what I mean? I mean, then you're out the security deposit. So more or less, but yes, you can take it. People ask me that, so that's why I brought it up. You can take the money out of the security deposit. Like I said, they're supposed to be paying rent. It's just you can't evict them. So I'm not sure how else to answer that. The point is you can do it. Unless you're in certain cities. Let me take that back. Certain cities say you can't do that.
Today, at least. We'll see where we are tomorrow, right?
Right. Stay tuned tomorrow.
Well, thank you so much, Gov, for your time today, for our membership, for Laguna and Newport's membership. I mean, we are so grateful to have you on today. I'm sure that everybody was grateful to hear what you had to say. And
It's been a pleasure. Laguna and Newport, two of my favorite places. So please invite me there as soon as we're allowed to travel.
We will. We definitely
And I will
will.
come visit. All right.
Okay.
Thank you, everyone.
Thank
Bye,
you.
guys.
Bye.